In today's episode, we take a look at a case where a Delhi student who died by suicide has triggered an inquiry into alleged teacher harassment. We also talk about a peculiar new crime wave in Maharashtra targeting one of the state's most valuable fruit, the pomegranate. But we begin today by explaining how the Supreme Court has redefined the boundaries between governors and state governments, revisiting its own timelines for how long a governor can sit on a bill. Hi, I'm Ichha Sharma, and you're listening to Three Things, the Indian Express news show. Among the key points of tension between the states and the centre has been what a governor who is appointed by the centre should and should not be able to do. Recently, these tensions had come to a fore when the Tamil Nadu governor R.N. Ravi withheld his assent to 10 bills of the state assembly, further escalating the tussle between him and the ruling DMK. Later, Tamil Nadu, along with other states, had approached the Supreme Court and set aside Governor Ravi's decision, calling it illegal and erroneous, and actually set timelines of 1 to 3 months for governors to act on the bill and effectively pass those 10 bills which were pending. Now, in response to this, President Draupadi Murmu had posed 14 crucial questions regarding the verdict. So, addressing them, a 5-judge constitution bench on Thursday rolled back the timelines it had set earlier and said that the judiciary cannot impose rigid timelines on constitutional authorities. Now, to talk about what the bench discussed and the implications it has on the governor's role, my colleague Shashank Bhargava speaks to the Indian Express's national legal editor, Apurva Vishwanath.
Apurva, because we'll be talking about the role of the governor in quite a bit of detail, could you talk about why this is an important issue, why this matters?
So this becomes really important because the governor is envisaged as this link between the centre and state. The centre, the president, with the aid and advice of the cabinet, which is the central government, appoints a governor. And in states, states can be ruled by the same party at the centre or by opposition parties. So the governor becomes this link between the union and the state in many ways. Having said that, most of the functions of a governor are nominal, titular, and are remnants of what they used to do in colonial governments. So this link is there, but the governor is largely required to depend on the aid and advice of the state cabinet. So this is a system that works as long as the office of the governor doesn't become a partisan one, doing the centre's bidding in the state government and things like that. It's a constitutional post, so one expects the Raj Bhavan to act with the same sense of neutrality that the constitution sort of trusts the governor with. But we've seen that that's not been the case in the last few years.
Yeah, and talking about the role of the governor, we know it is the governor who grants assent to bills. Without that, they can't turn into laws. The governor also decides who should be invited to form a government, particularly when there is no single party with a clear majority. The governor is also supposed to grant pardons, decide mercy petitions, and grant sanctions. And this is again something where we've seen tensions arise in the past, governors granting sanctions. And it was in the context of the governor's role that earlier in April, the Supreme Court was looking at the case of Governor R.N. Ravi. So could you talk about what the April judgment talked about and what reason had the court cited to set timelines for governors?
So the April judgment was, in a sense, a culmination of a simmering debate for the last few years, right? So it's not as if it came out of the blue, but several opposition ruled states from Punjab to Tamil Nadu, Kerala had all moved the Supreme Court, saying that the governor's been sitting on certain bills and essentially negating the role that the democratically elected state government plays, which is in lawmaking, right? So constitutionally, the governor has 3 options when a bill is sent to him for assent. The governor can give assent, the governor can refer it to the president, or the governor can simply reject it, unless it's a money bill, in which case the governor cannot. Right. So in many of these cases, including some like, appointment of vice chancellors in universities and things like that, governors had been sitting on these bills and leading to a constitutional impasse, because that means the government can't pass the bill. It's not a law yet. And there's no other recourse for the state government in that sense. So the state governments kept coming to court saying essentially what the governor is doing is exercising a pocket veto. That ultimately, if he sits on a bill, it can take years and the bill lapses.
And here it's important to note that if the governor rejects a bill and sends it back and the legislature passes it again, then the governor is required to give assent.
Yeah. And, an elected state government has a tenure of 5 years. So if a governor is sitting on a bill for 3 years, then it essentially means that they will be fighting in another election before, they can exercise their power in lawmaking. So the court did censure the governor once in a while and asked them to reconsider this. But when things didn't move, the case was heard for final arguments and there was a decision by a bench of Justices J.B. Pardiwala and Mahadevan. So what this judgment did was, of course, say that these actions of the governor are erroneous and against the spirit of the Constitution. So that reining in and that acknowledgement was very important. It is a federalism issue at the end of the day. India is structured in this quasi-federal nature where there are 2 tiers of governance, and the direct governance for people happens in many ways through the state government, right? So, and if that is kind of brought to a standstill, that means that the will of the people is not being given effect, that my vote doesn't mean anything. So that acknowledgement was very important from the Supreme Court, but the court went a step further and said, this is what needs to be done when such a situation arises again, right? And that prescription was setting timelines for the governors to give assent. And in the case of Tamil Nadu, because there was this back and forth constantly with Governor R.N. Ravi, the court gave something called a deemed assent. The court said, these 10 bills which are part of this litigation, we are giving assent as if the governor has given assent to them. Right. And another step further is, because R.N. Ravi did this little trick that when the Supreme Court kind of gave him a last opportunity, those bills were referred to the president. So which means, again, it's out of his hand and it's on the president's desk. So the court kind of recognized this and said, even if you send it to the president is also bound to decide it in a particular time frame. And in case it's taking longer for the president or the president has doubts on whether this bill should be given assent to or not, then the president can ask the Supreme Court in advisory jurisdiction and so on and so forth. So this last part, of these strictures for the president raised alarm bells in the government about what are the consequences of, or where the situation would lead. So that's the context in which a reference was sought by the president from the Supreme Court.
Right, and it is in this regard that this 5-judge bench was formed. Talk about what this bench looked at and what is the reason that it overturned its decision regarding setting timelines for governors.
So the April ruling has these strictures for the governor and president that you have to do X, Y, Z in case such a situation arises. So the crucial question is, what happens in case they don't, right? Will you hold them in contempt? What consequences will that lead to where the president of the country is being held as violating or breaching a Supreme Court directive, right? And these are essentially political questions which are presented to the court as if they are purely constitutional ones. So it is, of course, a complex case, but it's also completely uncharted territory for the court, because if you say that if the governor doesn't give assent, then we will do it on the governor's behalf, that is usurping the power of the executive, right? One constitutional authority essentially performing the functions of another. And these also can lead to very bizarre unintended consequences. So that is what the court had to address. And the government came to the court asking for an advisory opinion, which is basically consider it to be like an off-the-books advice that the government gives to the president, because it is the duty of the Supreme Court to interpret the Constitution. So when the president has a question on whether something is constitutional or not, the president can ask this question to the Supreme Court and they answer that, the way the president has asked. In many cases, the court can choose not to answer. In this case, there was a view that the court should choose not to answer because there is a judgment of the Supreme Court, which is the Justice Pardiwala judgment, saying what is the legal provision. And the law laid down by the Supreme Court is, of course, the law of the land. But having said that, because of the political consequences that we just discussed, the court did answer this question, this reference by the president. There were about 14 questions. And essentially this, right, whether the Supreme Court was right in taking over the function of the governor, even in case of a constitutional impasse, right? So what can you do? So I think this aspect of drawing this line in the sand on separation of powers, because it's very, very important, because tomorrow the executive can say that there is something that the judiciary hasn't been doing, so we will do their function. And that separation of power is very important.
So basically saying that, look, you stepped into our domain, so now we'll step into yours.
Yeah, and a cardinal principle is that we don't overstep into each other's domain. There is some sort of overlap, of course, in our constitution, but where it is expressly mentioned as a power of one constitutional authority, another one cannot take it over and, start doing that function. And also, given that this is a center state question, right? Tomorrow, these roles can be reversed. They can be a governor from a different political party in a BJP ruled state. And, the consequences will be the same. So given all this complexity, the Supreme Court decided to roll back on that particular aspect, which we talked about as possibly overstepping its mandate, right? Which is having those strict timelines and a flow chart for what happens when a bill is sent to a president or the governor for assent. So that part the court has rolled back on. Having said that, this is an opinion that the court has given to the president. It is not binding on the president, let alone the court. But what this kind of represents is a thinking of the court, right? So that April judgment was by a 2-judge bench. This is a 5-judge bench, including, couple of future chief justices. So it represents the thinking of the court. So this 2-judge bench judgment still stands technically. So next time a case comes before it, it will have to be reviewed, and this 5-judge opinion will have to be taken into account again.
Okay, so just to be clear, the 2-judge bench judgment still stands. And what this 5-judge bench did was just give its opinion that, this is what we think. So the next time something like this comes up again, for example, if another governor is sitting on bills for a really long time, and if that case goes to court, those timelines will have to be revisited again.
Yes, because, these are two fundamentally different functions of the court. What we saw in April was an adversarial dispute between the state and the governor. There was a set of facts and the court decided the case in one way or the other. And that is the law of the land. What happened this week is essentially in its advisory opinion. So, which is basically advice that the court is giving the president. It is, of course, very, very practically very difficult to disregard this advice that the court has given. But this is still going to be litigated and navigated further. Because, even in the advisory opinion, the Supreme Court has kept the door open for the states to approach the court. The court says that there is a judicial review, even if it's limited, that when the governor sits on a bill for an indefinite period of time, causes undue delay, states can still come to the court. The only thing that changes is the court is saying that it will be some kind of facilitator of dialogue, that we will still issue notice to the governor, that we will hold space for the center and state to talk, rather than the court just taking over the function of the governor and doing it for themselves. So politically, what this means is, given that the space is shrinking for the opposition, if they are fighting against the center, there isn't another avenue that the state can go to, right? Either you face elections or you go to the court. And even if you face elections and win your state again, if the center wants to oppose you, there is, it puts the state on a back foot, right? So the court is saying that you can come here and we will hear you and we will kind of mediate this between the center and state, but we can't take over the function of the center and kind of do it for them. So in that sense, it's a rollback of its position. But the court is also drawing this red line for itself, saying that we cannot take over and do this function, even when we know that the governor is not performing their actions.
So let's talk about some of the questions that the court discussed about the governor's role. And one of the main ones, of course, was what should the governor do in terms of its legislative powers. Tell us, what did this 5-judge bench say about how long should governors wait on a bill, since this bench did not prescribe a timeline?
Actually, if you look at the text of the Constitution, Article 200 says, as soon as possible. As soon as possible, one can assume that the framers of the Constitution deliberately left it vague enough for the governor to fix his timeline for themselves. So the court says that it's not my job to give you that as soon as possible is 3 weeks, 6 weeks or 10 weeks or whatever. But if there is an inordinate delay, then you can come to court and we look at it. So which means it's essentially a case by case basis, right? But what this whole episode also tells us is the limitations of this constitutional scheme of things we have. There's one paragraph in the judgment that kind of encapsulates this. And the court says that the working of our constitutional scheme is premised on the constitutional authorities actually making the constitutional scheme work. So they basically are saying our constitutional scheme works only if it is worked. That means people would want to keep it working, and that is for the center, that is for the states, everybody. So if the governor deliberately chooses or if the center deliberately chooses, it also shows that there is very little anybody can do. And the court is saying there's very little that we can do. So, which is why it's so crucial to have democratic constitutional functionaries do their job and run the country in a responsible manner.
Right, these are two constitutional bodies. You can't have one stepping over the other. So basically what the court is saying is that you better act responsibly if you are in such a position.
Yeah, and this is essentially saying that we don't have a solution to this problem either. Because nowhere is the court saying that it is the governor's prerogative to sit on bills. They are not saying that the governor can effectively veto a democratically elected state government. They're telling the governor all of this is wrong. They are saying that deliberate inaction can defeat the constitutional scheme. But having said that, the court is also offering no other solution except for holding space for a dialogue. You can argue that this is a cop-out by the court. But the other side is also that if the court takes on and does this function, then there is no line in this constitutional scheme between what is the court's job and what is the executive's job. So if anything, this judgment should be read as a warning of how bad things can get if one of the constitutional functionaries decide to go rogue, essentially.
And we understand that the governor generally acts on the aid and advice of the Council of Ministers. So is the governor bound by that when granting assent to bills?
So there are different kinds of functions that the governor performs. And for most things, the governor is bound by the aid and advice of the cabinet. But in this aspect, in Section 200, which is granting assent to bills, the court says that there is more than just going by the aid and advice of the cabinet for the governor. That the governor is in some sort keeper of conscience, a check against the power of the state legislature, So here the court says the governor is not entirely bound by the aid and advice of the cabinet. I mean, if he was bound by, there was no reason why you specifically need assent by the governor otherwise, right? So that makes no sense. Having said that, this entire episode also tells you that perhaps there is no other real reason for having the office of a governor in our constitutional scheme, because the check against a state legislature is in every way the right to vote. The fact that they will be voted out by the people in the next election. So just having the governor who is essentially an agent of the union, which is how this entire role has become to be defined, right? Governors are not acting independently. They are acting as agents of the center, whether that is in the BJP's tenure at the center or earlier when Congress was in power and used the governors to topple state governments through presidential rules. So the governor is essentially an agent of the union. So maybe it's time to just retire the governor's post itself, because this sort of constitutional impasse, even this advisory opinion, hasn't really resolved in that sense.
And also, Apurva, what did the court say about whether it can actually question what the governor has done, whether it has or has not granted assent? Can it question that?
No, the court cannot go into the merits of the governor's decision because under the constitution, again, the governor and the president both enjoy immunity for their actions. But the court can certainly question the procedure followed to arrive at that conclusion, which means, is it right for the governor to return the bill or not is not the court's problem, and it's also an easier thing. If the governor returns the bill, the state government can simply just send it to him again, right? The problem is really when he doesn't decide at all. He just sits on it, right? Which is what Tamil Nadu's problem was, that the governor was sitting on bills for 3 years. So you keep the state in a limbo without telling them what you actually decide. So the court is saying that we don't have to look at the merits of the governor's decision. We just have to ensure that the governor makes a decision. It's as basic as that.
Also, since we are talking about whether this role should even exist now, what would it take for the role of the governor to not be there anymore?
It would take a constitutional amendment. You have to amend the constitution and change that part. Of course, that will be put through a test of whether that forms part of the basic structure of the constitution or not, and the court will have to look at it. But for all practical purposes, I don't think federalism is part of the basic structure, but having a governor as a post is probably not. So if there's some really strong central government which has no incentive in giving some of its people post-retirement gigs, they can bring in a constitutional amendment and retire the Raj Bhavan.
And have there been calls for that in the past? Because it's usually, opposition states that have problems with the governor. But do their opinions change when they come to power?
I mean, that's been our experience, right? Indira Gandhi notoriously used the governor's office to topple state governments. The Supreme Court had to intervene. The president's rule sort of was. There are fewer instances of using the governor to impose president's rule now because the Supreme Court has had to intervene so many times. And now there is enough court verdicts that tell you what you can do and what you can't do. Right? So that is decades of litigation. And now we have come to this point where that is not the preferred mode. I mean, central governments still try to topple state governments through other means, say using ED or anything else. But the president's rule as a choice of weapon is kind of phased out. So that's not the thing anymore. But, that's the thing, right? Like governments will change and someone else will come to power and they would still want to have the same authority over this. So they would not, there's no incentive for anybody to actually look at this structural issue.
And next we shift our focus to Delhi, where a student's suicide has sparked an official investigation into alleged teacher harassment. Last week, a class 10 student from St. Columba's school died by suicide, which has since triggered both a formal police investigation and a high-level probe ordered by the Delhi government. 2 days after the 16-year-old jumped to his death at the Rajendra Place metro station, his family came forward alleging that he had faced repeated humiliation and threats from teachers at the school. In response to these allegations, St. Columba's, an institution whose notable alumni include figures like Rahul Gandhi and Shah Rukh Khan, has suspended 4 staff members, 3 teachers and a headmistress. When we spoke to the Indian Express's Upasika Singhal, she told us more about the case and the boy in question.
So, talking to the victim's family and friends, we sort of understood that he had never had any problems in the school before, but ever since he entered 10th class, or ever since he started 10th class, the teachers began to really put a lot of pressure on him to perform better academically. And apparently, allegedly, this would happen through means of public humiliation. They would make him stand in front of everyone and they would scold him and, they would say some really hurtful things to him. So apparently this sort of behavior escalated in the last 2 to 3 months back. And the day of the incident, the day when he died by suicide, there was an incident in the drama class where he kind of slipped and fell. And after that, the teacher kind of started rebuking him in front of everyone, started humiliating him. And it was so bad that he started crying in front of everyone. And the teacher just very flippantly apparently said that, I don't care how much you cry, all of whatever you're doing is just dramabazi. And I think this was kind of the last straw, that the final thing that broke him. He had been pleading to his parents to change his school because he couldn't take it anymore. And the parents said that just give us till the end of your academic year because, nobody's going to take you in another school now. Unfortunately, he couldn't really, take it anymore. He couldn't bear it anymore. And that's what led him to take a very, very drastic step. Very tragic.
And Upasika, during your reportage, you spoke with his family and his friends. So what did they tell you about him? How was he as a student?
He was a very bright, very smart, very creative boy. I mean, he was extremely invested in his extracurricular activities. He loved to dance. He loved to play sports. He was very into running and he loved to act. His dream was to one day, try to make it into Bollywood and act in movies. He'd also told his parents very openly that, after I finish my college, after I finish my studies, I want to take up acting classes. I want to try making it over here. His friends also told me that he used to write movie scripts He was very good at it. He was very creative in that way also, where he would just have an idea and in the next few hours he would have like a rough script ready, and very extroverted, very gregarious kind of a boy. His dad also mentioned that he loved going for MUNs, and last month he had won a competition against another school in a dance competition. So he was a very creative boy, and he was, I mean, by this, from whatever I heard from others, like he was extremely sharp. It's just that, like he just didn't feel like applying himself to his studies, and he was more invested in his extracurriculars. So that's generally the gist of what I got.
Right, and we know that the student's father has filed an FIR against the school. So, could you tell us what exactly are the allegations made by the family?
So the father mentioned in his statement that there were four teachers in particular, including the headmistress, who would target him. And he also mentioned that, like, my son has been complaining about this for many, many months. And we have gone, like, the parents, they've gone and tried to, sort it out with the teachers and sit and try to understand where he's going wrong, what is happening. But he said that none of this ever led to a solution. Like, they would go meet the teachers, they would have a talk, and then the next day the same thing would happen. So he said that it has been becoming worse and worse in the last few months. He has been coming and telling us that, he wants to quit this school, wants to try it out in another school. FIR named these four teachers, and that's how the police also got to know, like, who to really, investigate. The boy in his suicide note has also mentioned these four names, and he's also, like, sort of said that such and such teacher said this to me, and this other teacher once said this to me, and I was really hurt. And it was honestly shocking to read and see what this boy went through.
And so, how have the school authorities countered these allegations? What have they said?
So, surprisingly, in the days that followed his suicide, the school administration remained completely mum about it. There was no statement, there was nothing from them. Like, there was not even like a generic sort of, an email to the parents or anything. Only yesterday, I think, when I was talking to the friends of this boy, only then did I get to know that the school has kind of acknowledged that a student has passed away, and they were taking the children closest to the victim, into counseling. And the only time that we got any sort of response from them was when they suspended those four teachers. And even then, there was no official sort of statement. We got to know from sources that they've been suspended.
Right, and Upasika, what about the parents and students within the school community? What do they make of this incident?
So yesterday when I went to the protest, there were a few parents who were present there. They said that the quality of teaching has really fallen in the last few years. One of the parents who was there, their child graduated from the school this year. And she said that, like, there's a lobby of teachers here, sort of, they favor certain students and they sort of pit students against each other. And she said that, my child is also faced these issues. And like, but he's, instead of, sort of doing anything about it, he just withdrew and concentrated more on his studies and just sort of, counted down the days until he graduated. Certain other parents that were present there, they were also kind of saying that, there's very little care shown towards the children. And whenever the parents have sort of confronted teachers about this, they've said that, we are handling 50 students per class. Like, you can't expect us to give individual attention to each student. So, yeah, there were a lot of complaints from the parents' side.
And also, how common are such cases in the school? Did any of the students you spoke with share similar experiences?
I did find a student who left the school in 2024 who said that, listen, like, the kids who didn't face anything were the kids who were getting good marks. I know how it feels and to be treated this way because I was one of, so-called bad students. He said that, one teacher told me that I pity your parents for having a son like you. I mean, it's so bizarre that you would say that to a child because you're the adult in the situation here. You're not supposed to lose your cool. But yeah, he said that, students who wouldn't perform well would be seated separately from the class. If you really get on the bad side of certain teachers, they would ensure that they will pull you up in front of everyone and sort of giving you a dressing down in front of them. They would also put a lot of pressure on you by saying that if you don't do well in this exam, we're going to get you rusticated, which at that age, I mean, it's like life or death, right? Like it's so shameful to be rusticated. Yeah, so this constant pressure would just sort of be built on these students that they needed to perform well. And especially in the years where you get boards, where 10th and 12th, like this child said that it was really, really tough to pass 10th because there was such a lot of pressure that was constantly maintained over me to get passing marks. And yeah, he had to leave that school the next year in 11th class. And he said that I was so happy to leave this place. And I went to open school and I completed my studies and I got an 85%. So clearly, like I was not academically slow. I was just not getting the right guidance.
And lastly, Upasika, we understand that the Delhi Directorate of Education has formed a 5-member inquiry panel now. So where does the investigation stand? And could you tell us what next can be expected?
So, at least from the police front, they are interrogating 4 teachers who've been named. There's also the FIR against them. They've applied the section of abetment of suicide against them. I think at this point, all of us are just sort of waiting for, their explanation of what happened, like how could such a breach of conduct happen, and how could they just let these scores of children are coming out and saying these things now, and like how has this happened in such a reputed school? They must have some explanation. Apart from that, the 5-member committee has been given 3 days to investigate this incident, and I think they're also going to look at the larger picture of things, where they're going to sort of see that how are the teachers behaving with students, where are they lacking, and things like that.
And in the end, we head to Pune, where a very unexpected crime wave has hit Maharashtra's farms. Not onions this time, not even sugarcane, but pomegranates. And not just any pomegranates, a premium variety prized for its bright red rind and high market value. Between July and August, a series of highly organized and strangely discerning pomegranate heist operations have left farmers puzzled, stressed, and in some cases, patrolling fields at night. As reported by the Indian Express's Shashank Kulkarni, the first reported case occurred in the Shindoli village, where approximately 4.5 tons of the fruit had been stolen overnight. An FIR pegged the loss at 4.5 lakh, but the farmer who filed the complaint estimated the value to be double in wholesale markets and even higher in retail. He said the fruits ready for harvest after 7 months of cultivation had been selectively plucked, indicating that the thieves understood the market and the crop. And this wasn't a one-off. Similar thefts were reported in Sholapur Sangola, Ahilyanagar's Srirampur, and Nashik's Deola. In each case, the stolen fruits were large-sized, high-grade produce, suggesting organized operations. Farmers and police linked the thefts to soaring pomegranate prices this season. Wholesale prices rose nearly 200 rupees per kg, almost double last year's rates, due to a drop in supply caused by unseasonal rains, crop disease, and disrupted flowering cycles. Kulkarni notes that at Sangola's Hadith village, farmer Altaf Mullah said thieves stripped 300 trees in one night, stealing about 3 tons of fruit worth 8 to 9 lakh rupees. Following the incident, villagers began community night patrols for protection. Now in Srirampur, farmer Satish Jadhav lost 3.5 tons valued at 7 lakh and reported that leopards hiding in the orchids made the vigil dangerous. Similar leopard sightings were reported by farmers in Shirur. Now, the farmers have noticed something else as well. The thefts always happened just days before harvest at the same time when traders from states like Jharkhand, Telangana, and Madhya Pradesh were visiting the region. Police believe that organized gangs familiar with the pomegranate trade carried out the thefts, possibly aided by market insiders. Pune Rural Police confirmed 2 theft cases registered in Shirur in July, leading to 1 arrest so far. Inspector Sandhish Kenjale of Shirur Police Station told the Indian Express the thefts followed the same pattern as previous agricultural crimes, where rising commodity prices such as onions triggered targeted thefts. Investigations are ongoing to identify the larger network behind these coordinated crimes. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava and me, Ichha Sharma. If you like the show, do subscribe to us wherever you get your podcast. You can also recommend it to someone you think may like it, with a friend or in your family. This is the best way for people to get to know about us. You can also tweet us at Express Podcast or write to us at podcast@indianexpress.com.